I will limit my talk to these 4 items. I want to talk a little bit about what resonance early law has today. Are any of these colonial laws still in the books? And more than that, what imprint have these early laws left on the present day legal system? Next, I'm going to take a look at the 3 New Jersey constitutions, and then take a quick look at the New Jerseyans who have served as justices on the U.S. Supreme Court. And I'll end my discussion with just a few landmark cases that were decided by the New Jersey courts. You tell where I was born. But New Jersey cases that have nevertheless had a national impact. And where possible, I'll talk about where you can find those primary documents. We heard a great deal today about the proprietary period from John and Joe, and I won't spend too much time on that, but I do want to talk about, what for my money is the most exciting bit of foundational documents, and they come from the province of West Jersey. It lasted 28 years or so at the end of the 17th century, but it had an amazing set of laws. We heard about how it was carved out of this huge grant from the Duke of York and given to James, later King James II. He doled out pieces of his big grant to his pals at court, Lord Berkeley and Sir George Carteret. And these were not guys who were going to pick up and get on a boat and go over there with a hoe. No, they were big shots at court. Carteret did have some distant cousin who he sent off there, but Berkeley was looking to cash in on this grant as quickly as possible. And the Quakers, who were looking for a good deal in the New World, struck a deal with him and settled in West Jersey. And they drafted a charter of fundamental laws of West Jersey. And you can find this document in Lyons and Spicer, which we've heard a bit about. It's in a lot of libraries because it's been reprinted a number of times. Not that you might have the original 1758 version, but we've also digitized it because it's an important bit of our history. And so you can find Lyons and Spicer on the website of Rutgers Law Library in Newark. Here, I want to show you one bit of it. This is an article dealing with the courts, and yet there's this thing at the end that says, by these are concessions and fundamentals that all and every person and persons inhabiting the said province shall, as far as in us lies, be free from oppression and slavery. So, was this an abolitionist colony? It's not exactly clear. I mean, there is certainly slavery in East Jersey that predated even the English. But West Jersey was a smaller, more cohesive Quaker foundation, and perhaps it is a slavery-free province. Here's the language on religious freedom. This is something that the proprietors had a bit of help with. About 10 years earlier in Rhode Island, the colony founded by Roger Williams, they come up with a charter that has a very strong religious freedom clause, but this even goes a bit further. Nobody can mess with my beliefs. It's just extraordinary. And it even seems to permit perhaps atheism. It doesn't say that explicitly, but whatever you want to believe, it's okay with the proprietors of West Jersey. This goes further, I think, than pretty much any colony at the time. You don't see language this strong again for another 100 years. A few more things about the colony of West Jersey that I just want to highlight. They had, at a time when in most of England and its colonies, the penalty for theft, it was a hanging offense. In West Jersey, the penalty was twofold restitution. If you stole somebody's chicken, you had to give them 2 chickens back. And if you didn't have 2 chickens, you could work it off. The only capital crimes in West Jersey were murder and treason. And there's no record that anyone was ever tried for either of those crimes. And everyone was guaranteed a jury of one's peers. If a Native American was put on trial, 6 of the jurors, half the jurors, had to be Native American. You don't see that in too many charters. One can see the influence of this charter, not so much in later New Jersey law, sadly, but you do see it in other state constitutions. I think especially in Pennsylvania, where, again, there's that strong Quaker influence, but in other states that have a strong Bill of Rights. So even if this language may have been forgotten for some time in New Jersey, I think it did have quite an influence on perhaps our National Bill of Rights as well as the Bill of Rights that exist in other state constitutions. So, 1702, that's the end of the experiment. The proprietors surrender their rights to make laws back to the Crown. And you can see in these documents, the surrender and the instructions to Lord Cornbury, that there's some bargaining going on. The Queen is taking control again, and the happy experiment is over, but there's bargaining over, don't get rid of all of our elected officials. Show some respect here. So there is a religious freedom clause in the instructions to Lord Cornbury, except for papist. That was the Queen's language. There are limits. But so we have a new set that provides the basis of fundamental law from 1702 to 1776 going forward, and it replaces many of the laws of East and West Jersey. Not all of them, but quite a few, and then there's statutes enacted beyond these fundamental documents. So, does any of this old stuff matter today? I think it does matter. I think that the DNA of our present legal system is traceable to these colonial times and to England before that. For one thing, the New Jersey Constitution, every New Jersey Constitution has explicitly preserved past laws unless they're explicitly repealed. Here's the very first Constitution, 1776. And this is understandable in the first Constitution, right? They're in a bit of a rush, right? They just want to get rid of those laws about paying taxes to the king and keep all the other stuff, the penal code and inheritance laws and all of that. So they say, everything else stays in place. I think after the Revolutionary War, certainly laws were changed. They got rid of the things that were most offensive. This whole thing about primogeniture. If you're the firstborn boy, you get the whole grant. There were a lot of second sons from England who came here, and they didn't like that. So they reduced some of the harsh laws. But it takes an affirmative act of the legislature or of the courts to get rid of old laws. And one might argue that the great virtue of our legal system is that it preserves the wisdom of the past and it insulates us from radical and sudden change. And I think you could also argue that the great fault of the legal system is that it preserves the past. And it drags the prejudices, the inequities, the ignorance and hatred of the past into the present day. And I'll give you a few examples of how these colonial laws remain with us. A few of them kind of trivial, but some of them I think more substantial. So let's take a look at the trespass by swine statute. This was a colonial era law. It was enacted in 1709, and apparently there was a great problem of pigs trampling through their neighbors' gardens and doing quite a bit of damage. And this law said that if you found your neighbor's pig trampling through your garden, you could kill it and you could have it for Sunday dinner. There was abuse. The following year, it had to be amended because, what if that pig just trampled over a bit of kale or some overgrown zucchini? You weren't going to eat those anyway. So the new law said you could still kill the pig, but you could only consume so much bacon as was necessary to compensate you for the actual damages, and the remainder of the pig had to be turned over to the overseer of the poor, who would distribute it to the needy. Now, that law was with us for a long, long time. In the 1990s, the New Jersey Law Revision Commission decided to take a look at some of our old statutes and maybe get rid of some things that perhaps were no longer necessary. And so they did repeal that, but they got some pushback because people were laughing at them and say, oh my goodness, trespass by swine, we still have such a crazy law. So statutes for trespass by stallions, bulls, and rams are still very much a part of the New Jersey statutes annotated. Now, again, here the language from the constitutions of 1844 and 1947 that again say anything on the books that's not explicitly changed by this new constitution is in full force and effect. And that's how these laws that are 200 and even 300 years old are preserved. Give you another example. Not only were there actual statutes that were brought into our code, there were common law offenses that were imported directly from England. This is a description from Blackstone about what a common scold was. This was an offense that could only be committed by a woman. And the crime consisted of the woman being, argumentative and just a general nuisance to her neighbors. It was something for which the traditional punishment was a dunking in the river or pond, whatever was nearby. Nothing like a little bit of waterboarding to teach the ladies to mind their tongue. In New Jersey, though, the offense was merely a misdemeanor. But women were charged with this offense as late as 1972. In fact, there's actually in the New Jersey Digest first series a topic, one of the major divisions of subjects on cases. Common scold is a West topic. So finally, there was a Monmouth County Superior Court judge who had this case before him where a woman was charged with being a common scold, and he had the wisdom to say, it's constitutionally kind of a problem, equal treatment and the 14th Amendment and all of that, and he said in this decision that being a common scold, no longer a crime. I was alive in 1972, that took a while. One thing that's also very much with us is Title 44 of the New Jersey Statutes Annotated, the Poor Law. Our current law goes back to 1758, or again, a Royal Colony Act. Before that, there was a 1709 Act. The 1709 Act is pretty benign. There's still a lot of Quakers in government. And that just says that we need some kind of taxing on a county basis to provide for orphans and the poor and so forth, and it's not very detailed. But the 1758 Act is a much harsher kind of statute, and it provides, first of all, a distinction about whether someone is well settled in a township or county, or whether they're just some, invader from New York or something, in which case they can be deported back to their original township or county or state colony. If they come back, they can be flogged. And it sets up a whole system of workhouses and overseers of the poor, which is like the county welfare official. And so the law that was passed in 1758 was nothing new. It mirrors pretty closely a law that goes back to Queen Elizabeth, the English Poor Law of 1601, which was on the books in England for, a good 250 years. And the tone of our current day law, it's nothing like this, right? It's a modern day welfare law, but the tone, I think, creeps in to our current poor law, and we still have a term, it's still part of our code, a definition for overseer of the poor. And I checked on this before, as I was putting this together, and I saw, oh, wait, there's something in the pocket part. Maybe they got rid of that. They made it gender neutral recently, but the term still exists. You can find all the laws of the Royal Colony of New Jersey in the series from the New Jersey Archives. And I know a lot of people probably have that in your libraries. I don't know if that was a depository item, but I know we have 2 copies of it. And it's a really useful thing to trace the history of current laws still, because they have some of them, if you look at the notations at the end, will go back into this colonial period. So now let's talk about our constitutions. 3 of them, they're the full text of them online, I think, at both the state archives and the state library. And here's an image from the state archives. I like this one because it has like the original pictures and stuff, but it has the text in a very readable fashion. So the first constitution was really a rush job. There's no Bill of Rights. Many state constitutions at this time have a Bill of Rights, not New Jersey. And there were these 10 guys who said, hey, we're gonna have a republic by the end of the week, and that's what they got. They printed 1,000 copies and got it out there. The thing that I find troubling about a revolutionary document in our first constitution is the last clause. It's provided always that it is the true intent and meaning of this Congress that if a reconciliation between Great Britain and the colonies should take place, well, never mind, forget about it. We didn't mean it. This charter is null and void, but otherwise, it's good. We hung on to that Constitution for about 70 years, and it had problems. By this time, many of the original colonies had already replaced their version 1.0. So version 2.0 of our Constitution, it finally includes a Bill of Rights. It extends voting to white men without property, though not paupers. And it did increase the power of the executive branch. Prior to this, we had a very weak executive. We had an appointed governor. Here we now have an elected governor who has a limited veto power. It only takes a majority of the legislature to override the veto, and since the majority of the legislature already passed the law, it wasn't a very strong veto power, but it was something of a change. The interesting thing here is Article 1, that says all men are free and independent, and they have certain natural and unalienable rights. Among those are liberty. And so there are a couple of New York attorneys, abolitionists, who look at that and said, oh, great, New Jersey just freed the slaves. Great. And they filed a habeas petition as soon as this Constitution went into effect. Now, New Jersey, back in 1804, had passed a law for gradual elimination of slavery. What it did is it said that if one was born to a mother who was held in slavery, that child would be freed after 21 years if a female and 25 years if a male. But around 1844, there's still plenty of slaves in New Jersey. Judge said, that's not exactly what we meant. The case arguing against this habeas petition was a Newark attorney by the name of Joseph Bradley, who I'll talk more about in a moment. He was a very successful commercial attorney, and actually his father-in-law was head of some sort of abolitionist society, but it's, it's business, it's a case. So slavery continues in New Jersey until the passage of the 13th Amendment, 2 years after the Emancipation Proclamation. Now, there probably weren't very many slaves left in 1865, but we are one of the last states to abolish slavery. Okay, so let's talk about the present Constitution. This, many people say our current Constitution is a model Constitution, and it's terrific, and many governors of New Jersey are particularly happy with it because it greatly increased their power. It provided for re-election of a governor. Under the 1844 Constitution, the governor couldn't secede himself, so pretty much term limited. And it gave the governor a much stronger veto power, and it also conditional veto. The thing that's important to me as a law librarian is that it merged the courts of equity and law, and so we have new books. That's a major, I think, accomplishment. The division of lawsuits into equity and law and which goes where, a source of confusion, and nobody's really doing that these days. It also modernized the Bill of Rights. It gives us an equal rights clause for women, an anti-discrimination clause, workers' rights. It's a much stronger Constitution than we had before. The full text of not just the Constitution, but the proceedings are available here at the State Library. Actually, I think the proceedings of the 1844 the 1844 convention were available at the Rutgers Law Library site in Camden, and they're perhaps in the process of being moved, but it has been digitized. I think it's just not online at the present moment. Okay, so there are 5 New Jerseyans who have been appointed to the U.S. Supreme Court. Going back to William Patterson, one of the founders, to the current day, Samuel Alito. I'm going to skip Samuel Alito because he is more part of the present than the past. So I'll talk a little bit about the first 4. But before I do, there's one person I really want to claim as a New Jersey Supreme Court Justice, even though she went to New York. And that is Professor and now Justice Ruth Bader Ginsburg. She got her first job at Rutgers Law School. There was immense discrimination against women at that time, and getting a job at a law school was much easier than getting a job at a big firm. She founded the Women's Rights Law Clinic. She founded the Women's Rights Law Report, the very first journal to deal exclusively with women's rights. And I like to think Jersey sticks with her in her current jurisprudence. But like I said, she's not actually a Jersey justice. So, William Patterson, a true founder of the country. He was a signer of the Constitution, but also participated in the negotiation for what would occur in the Constitution, most notably the provision that gives smaller states equal footing in the Senate with larger states. And now New Jersey in terms of population is sort of more like a medium or even large state, but back then that was an important point of contention, and that was a settlement for it. He then became a U.S. Senator. He was the second governor of New Jersey, and he had to complete his resume by being appointed to the U.S. Supreme Court. Back in those days, if you look at, say, the early volume, first volume of U.S. reports, they don't seem to be doing very much work, and that's because they're on the road. They are riding circuit and hearing appeals from all kinds of state and other federal courts. There's not a well-established federal judiciary at this point. And he was badly injured in a carriage accident. Imagine going over unpaved roads to all these different states and hearing cases. And so he died some months later following this accident. So tough life being a justice in the early days. The next justice I want to talk about is perhaps better known. Joseph Philo Bradley was a railroad and corporate lawyer. His papers are at the New Jersey Historical Society in Newark, and actually a good chunk of his library is in my library at Rutgers Law School. He had a very fine library and good taste in books. He's sometimes noted as the tie-breaking vote in the 1876 Tilden Hayes election. The Democrats thought he would side with them, and he was a Republican, and the Republicans thought he would side with them. And some people say he was involved in some kind of deal there. In terms of like notable decisions, there's quite a few, but I'll point out two. One is the case of U.S. v. Cruikshank. This is a case, a Reconstruction era case from Louisiana. There was an election for governor. There were many African Americans who were in office in Louisiana towns at this time and who were voting. And the ballot boxes went to the courthouse, and there were crowds who were afraid that, you know, the Republicans would be elected again, the Republicans being, you know, the Reconstructionists, the Northerners. They surrounded the courthouse, and there was actually a massacre where there's disputes anywhere from like 50 to 500 people are said to have been killed. The U.S. prosecutor at the time found some of the people who were accused of committing this massacre and put them on trial. The local county prosecutor or parish prosecutor refused to prosecute them. They appealed that, saying that, you know, murder's not a federal crime, it's a state crime. And so it was Justice Bradley, riding circuit, who heard that case. And he said, yeah, that's right. You know, the 14th Amendment doesn't go that far. This is a state matter, no business of the federal courts. It was appealed up to the U.S. Supreme Court, and he did vote on this case, and though he did not author the opinion, though it looks very much like an opinion that he wrote some years later. And that's the opinion in the civil rights cases. So in 1875, Congress passed a Civil Rights Act that said there can't be discrimination in public accommodations. Things like transportation and theaters and restaurants. The 1875 Civil Rights Act forbid that. And indeed, there were instances of such discrimination in many states, both northern and southern. And they consolidated 5 of these cases. They went up to the U.S. Supreme Court. And what Justice Bradley's opinion said was the 14th Amendment only covered state action, and these were private facilities. And what it did was lay the groundwork for 80 years of Jim Crow laws. And I think you have to argue that Justice Bradley is probably one of the most influential post-Civil War jurists, not in a good way, but it took a long time to turn that around. Some of you may be familiar with the case of Heart of Atlanta Motel, where the U.S. Supreme Court in 1965 upheld the 1964 Civil Rights Act. And so did that overturn the civil rights cases? Well, not exactly. What the U.S. Supreme Court said in 1964 was that the federal government, through its power of the Commerce Clause power, could enforce these anti-discrimination provisions on public accommodations. Probably not mom and pop stores, which didn't have a whole lot of interstate commerce going on, but you know, most motels, bus lines, and everything are engaged in interstate commerce, and it effectively knock down Jim Crow laws. If you were to shepherdize or key cite this case, the civil rights cases, it has like a little yellow flag on it. This is astonishing to me. It's not bad law. Really? Well, no. I mean, one could argue, again, using this case as precedent, that the 14th Amendment is very limited when it comes to civil rights. Judge Malin Pitney. Honestly, I don't know much about Judge Malin Pitney. I'll tell you what I do know. He was a classmate of Woodrow Wilson. He was appointed by Taft, and there was a lot of opposition to him from labor groups because he was rather keen on issuing injunctions against strikes. But once he got on the court, he was also noted for some very pro-labor decisions. He upheld workers' compensation laws and worker disability laws. So, not a bad justice. Probably the most influential justice that New Jersey has sent to the court has to be William Brennan. Indeed, Samuel Alito, of all people, said he is the most influential justice of the 20th century. He was on there for a long time, 34 years, over 1,300 opinions. And he's noted for landmark opinions in the area of civil rights and civil liberties. But I think what he's really admired for by many law professors at Rutgers who knew him and others who have written about him was his ability to create a compromise. He would work on justices to get one vote shifted over. You know, what if we put this sentence in the opinion? What if we said that? And he got a lot of close cases turned the other way by his ability to negotiate those compromises. And, you know, I think Justice Ginsburg offered perhaps the highest praise. She said one of his major concerns was to take the preamble of the Constitution that says, "We the people," and make that "we" an ever larger group. His idea was to increase the people who would participate in our democracy. And, you know, the opinions that he's written on voting rights, on civil rights, on civil liberties, stand to this day. And they're so, I think, beautifully written in many cases that it's hard to overturn those. And I think even people like Justice Scalia have to respect those opinions. Okay, let me end with 3 landmark cases. Mount Laurel, Karen Quinlan, and Baby M. And all 3 of these cases are covered in a book that was published last year by Professor Paul Trachtenberg at Rutgers, and he covers 10 New Jersey cases that shook the nation. I'm just going to highlight 3 for self-interested reasons. Mount Laurel is a case that goes back actually to the late 60s, and we have digitized over 100,000 pages of case files from Mount Laurel. There are these 3 decisions that I think are probably the key ones. Now, there's some people say there's Mount Laurel 4 and 5, and maybe they're deciding Mount Laurel 6 right now. It is, unfortunately, a doctrine that is still very much contested. Here's the website where you can find the case files. And this is one of our first major digitization projects. So we are still working, I think, on tweaking this a bit and adding some metadata, making it more accessible, adding some access points, but everything is up there. Briefs, correspondence, complaints. And the idea behind putting this stuff up there is that if you really want to understand legal history, it's not enough just to read a court decision. You have to examine the underlying documents, see what they were talking about, see what they were struggling, what parts of those briefs made it into the ultimate opinion. And we're planning on doing that with a couple more cases. But let me tell you what the case is actually about. This is the lead plaintiff, Miss Ethel Lawrence, and her family had lived in Mount Laurel for generations, going back to colonial times. And she had 8 children, and when they got to be of an age where you want them to get the heck out of the house, they wanted to stay very much in Mount Laurel, but they could not find affordable housing. And so Mrs. Lawrence, with the help of the local chapter of the NAACP and church groups and community groups, came up with a plan to build affordable townhouses. And they got the land together, they got financing. The one holdup was that there was a requirement that for each unit of housing in Mount Laurel, you had to have a 1/4 acre. And that just made townhomes unacceptable in the township. And they couldn't afford to buy that much land. So they met with the mayor, they tried to get a zoning variance, and the mayor said to a community group, he said, if you can't afford to live in Mount Laurel, the answer's simple, move to Camden. Well, Mrs. Lawrence did go to Camden Legal Services, and brought the case that became Mount Laurel 1. And what that case said was, there has to be in every township, in every zoning, some provision for affordable housing. It was resisted despite the ruling of the New Jersey Supreme Court. It was very hard to push the local supervisors, mayors, councils to actually enforce this provision. So then we have Mount Laurel 2. This is a case that I believe they heard arguments for it like in 1981, and they took 2 years to think about it. They actually sent out like 20 questions to the attorneys, asking them, brief us on all these different questions. When they issued the opinion, it was like 250 pages long. It's a beautiful opinion, though, especially the beginning of it. The judges are so ticked off that their earlier opinion did not accomplish what they had hoped, and so they set up a mechanism whereby these disputes can be heard by a special judge who's appointed for that matter, and things start to move at that point. But I want to talk about one of the original attorneys on Mount Laurel 1, who represented Mrs. Lawrence, continued to work his whole career on fair housing, and he was instrumental in pushing through the Ethel Lawrence townhomes. These were finally built in the year 2000, 6 years after Mrs. Lawrence had passed away, and they're gorgeous. And you know, this is what they were fighting for back in 1969, and it took 31 years to accomplish. And you know, it's a wonderful community. It's won awards, and because of the Mount Laurel Doctrine, there are like 60,000 units of affordable housing that would otherwise not have been created. And so, yeah, here we are right now. The next case I want to mention, again, I think this is probably a landmark case nationwide, is the matter of Karen Ann Quinlan. This Quinlan was 22 years old. She was dieting for 3 days, fasting. She went out with some friends to a party and had a few drinks, a little Valium, not too much. But given that she hadn't eaten in 3 days, she went into cardiac arrest. She was resuscitated, but because of the lack of oxygen, she suffered severe brain damage and was in a persistent vegetative state. Her parents, who were devout Catholics, consulted with their priest on this and what they should do, and came up with this very careful set of rules about what they ought to do and what they shouldn't do, and they wanted the breathing tube removed. And they had to go to court to get that to take place. And after the breathing tube was removed, she lived for another 9 years. And they had no problem with that because they felt the breathing tube was hurting her. And they didn't, she also had a feeding tube, but they saw that as the kind of support that everyone should be given. The breathing tube a step too far. And I think the right to die is something that is still very much litigated. And the Quinlan case is one of the first decisions that we need to look at, and I think we may be looking at putting up some of the documents from this case. A case that we are currently digitizing as we speak. My colleague is busy supervising students who are digitizing these documents, is the Baby M case. And for those of you who don't remember the Baby M case, this was one of the first surrogacy cases. There was a couple, the Stearns, who the wife had, I believe, multiple sclerosis, and she was concerned about bearing a child. So they advertised for a surrogate mother. Mary Beth Whitehead answered the call, and her eggs were fertilized with the sperm of the father, Bill Stern. When the baby actually was delivered, she decided, this is my baby. And there was a struggle over this, and the court actually ruled in Mary Beth Whitehead's favor to the extent that they voided the contract. They said this is not the kind of thing that we should be contracting over. Those contracts are null and void. The second question, though, was where would the child go and who would have custody? And there's a standard about the best interest of the child in awarding custody, and after like lots of hearings and testimony, they decided to award primary custody to the Stearns. And those court files are I hope they'll be up in 2015, sometime soon. I just want to mention Melissa Stern, by the way, is now Baby M, 28 years old. She's married, living in London. Her dissertation get this right. Dissertation from King's College London is called Reviving Solomon, Modern Day Questions Regarding the Long-Term Implications for the Children of Surrogacy Arrangements. And it's not available on ProQuest. I want to get a copy of this. It's one of the cases that is analyzed in that book that I showed you, Courting Justice. And all of the, well, not all, many of the documents that I've mentioned and that also have been mentioned earlier today are available at the State Library, at the State Archives, and some of them at our library at Rutgers Law School. Thank you.